Okay, so welcome everybody to the Think webinar series, our monthly series of conversations with international law experts in which we discuss various issues of relevance to so many things that are happening in relation to Israel and the Middle East generally. Think, the Hague Initiative for International Cooperation, is a global network of international lawyers committed to the international rule of law. And we promote cooperation and are opposed to all efforts to demonize or delegitimize the Jewish state of Israel. And why do we do that? Because we believe that the state of Israel is a legitimate and important member of the international community of nations. And whatever criticisms we may have, and we do express criticisms and concerns about Israel, we don't support any political movement necessarily within Israel, but we support Israel's right to exist as a Jewish state within secure borders and to be treated fairly and equally as any other member of the United Nations. And so in this webinar today, we're going to address the question, has the International Court of Justice become a platform for anti-Semitism? And to do that, we have two wonderful guests with us today, Professor Leslie Johns from California, joining us from Los Angeles. We're very thankful, Professor Johns, that you're with us, and Professor Gregory Rose from Wollongong University in Australia, who's calling in from Israel. Before we get to our wonderful speakers, I want to just talk a little bit about the topic and why we're speaking about this topic. Obviously, the concept of anti-Semitism is a very delicate one, and we need to treat it carefully. What we don't want to do is to throw around this important terminology. I'm always a little concerned myself that we don't overuse the anti-Semitism card. But I think in this case, it's very much warranted because the International Court of Justice, as we'll discuss, has been issuing quite a number of decisions and opinions, even since the 7th of October 2023, while a war is going on, a defensive war in which Israel is protecting itself against genocidal attacks on all fronts. The court has been issuing pronouncements, and it's been doing so because it's being pushed to do so by certain states within the UN system. Let's first talk about what is the concept of anti-Semitism. And to do that, we'll turn to the International Holocaust Remembrance Alliance non-binding working definition of anti-Semitism, which is probably the most widely respected definition of anti-Semitism. And that is that anti-Semitism is a certain perception of Jews which may be expressed as hatred toward Jews. Rhetorical and physical manifestations of anti-Semitism, of this hatred therefore, are directed toward Jewish or non-Jewish individuals and or their property, toward Jewish community institutions and religious facilities. And the definition goes on to talk of a number of examples. Obviously, there are the classic cases of attacks on Jewish people themselves. But when it comes to the state of Israel, and this is where the courts come into play, because obviously the International Court of Justice is not dealing with the Jewish people as such. The Jewish people are not parties to the court. They are not before the court as a people, but the state of Israel is. And the definition of anti-Semitism talks about this question of criticism of the state of Israel. And it says earlier on in the definition that quite clearly criticism of the state of Israel is not in itself anti-Semitism. That's very important to note. We should all be free to criticize the policies, criticize even the way governments, the constitution of the government, things that it does and says. We're free to do that, and the people of Israel do that, and people around the world are free to do that. However, denying the Jewish people their right to self-determination, for example, by claiming that the existence of a state of Israel is a racist endeavor, is, according to the IRA, a form of anti-Semitism. So at the core of it, the right of the Jewish people to exist as a people in the land that is the state of Israel is a right that they have. And to deny that right is a form of anti-Semitism. At least claiming that the existence of the state of Israel is a racist endeavor would be a way of doing that. Another example of anti-Semitism is applying double standards by requiring of it a behavior not expected or demanded of any other democratic nation. So we can't apply double standards to Israel. Natan Sharansky, one of Israel's foremost leaders, and obviously himself a victim of anti-Semitism in the former Soviet Union, defined anti-Semitism, the three Ds of anti-Semitism, demonization, and the double standards that are applied to Israel, as well as the delegitimization of Israel. He says all three are examples of anti-Semitism, and that's reflected here in the IRA definition. And finally, holding Jews collectively responsible for actions of the state of Israel. Now, again, the court is not doing this, but we are seeing a remarkable rise in what is clearly anti-Semitic attitudes around the world. It's anti-Zionism. The latest is that the Zionists are to be eradicated, even physically eradicated. We're seeing this on the streets of our cities throughout the Western world. Just think of what happened in Sydney a few days ago, or in London, in many other places around the world. And Jews are being collectively held responsible for the actions of the state of Israel. Now, raise the question, are the decisions of the International Court of Justice feeding into that? And indeed, are the proceedings before the court examples or symptoms of anti-Semitism? Now, let's not forget that many members of the United Nations, a majority, are extremely critical, if not hostile, towards the state of Israel. A number of UN member states do not even accept the existence of the state of Israel. Up to 20 Islamic states. Think of Malaysia, for example, Bangladesh, Pakistan. They don't accept, they have no relations with the state of Israel because they don't accept its legitimate existence as a Jewish state. So there is a large number of UN member states who are pushing many of these proceedings before the court. So we want to dig into all of this. And in order to do that, I'm delighted to welcome our two guests. Professor Leslie Johns, as I said, from UCLA, is a professor of political science and law at the University of California, Los Angeles, a research and teaching lie at the intersection of international law and international relations. And she's written extensively on the International Court of Justice. She is one of the world's experts on what the court is, how it functions from a political and legal perspective. So Leslie, we're delighted to have you. Thank you so much.
Thank you so much for having me. So I thought I'd start my remarks just by giving some background information to make sure everyone's on the same page. So the ICJ can hear two types of cases. The first is contentious cases, and those are brought by one state or a group of states against another state. And obviously, the case that was brought by South Africa against Israel alleging genocide is an example of a contentious case. The ICJ can also hear cases called advisory proceedings. And this is a special procedure whereby an international organization can go to the ICJ and ask the ICJ to issue a legal opinion on a particular legal question. And that is what several of the more recent rulings involving Israel have been. Those have been proceedings that started by a vote of the UN General Assembly, which is obviously an institution that is sort of notoriously biased against Israel. They have passed a series of resolutions over time asking that particular legal questions go to the ICJ. The ICJ then hears legal arguments that are put forward by basically anyone who wants to participate, who's part of the UN General Assembly, can participate. And then it issues a ruling. Now, the rulings in advisory proceedings are technically considered non-legal, but as sort of one of the preeminent courts in the international system, they are given a lot of deference, and it is a type of thing that's taken very seriously in public opinion and publicity. It's a type of thing you see in the newspapers. So I think it is something worth paying a lot of attention to. Now, historically, these advisory proceedings were initially, when the ICJ was created, meant to hear disputes involving like international organizations themselves. So early advisory proceedings before the court involved things like, do people who work for the UN have diplomatic immunity? Or what happens if a UN employee dies while in service? How are the survivors of that employee? Do they get pensions? Things like that. So it started off as a relatively narrow technical procedure, ruling on sort of legal questions having to do with IOs themselves. But over time, states in the General Assembly realized that this was an opportunity to bring what I would say are oftentimes political disputes to the court, where maybe the court otherwise couldn't get involved for jurisdictional reasons. If they could get a UN General Assembly vote through, that could get an issue to appear before the court. So there's sort of been a change over time in how these proceedings are going to work. I guess as part of my presentation, I was planning on making 4 major points. The first point that I would make is that the ICJ is not an institution that is designed for fact-finding. And in that way, it's very different than the way we think a normal domestic court or a criminal or civil trial might work. So unlike a domestic court, the ICJ places relatively little weight on like an active trial with oral hearings. Most of the back and forth at the ICJ involves the exchange of written pleadings between different parties. And in those written pleadings, because there's no international police force, there's no international Ministry of Justice, states, for the most part, can feel free to put forth whatever facts they want to put forth in their written proceedings. There's not really any sort of international authority that can clearly say, this particular event happened on this particular date. States can simply assert what facts they want in the written proceedings. Now, obviously, another party can contest those facts, but there's not really a hierarchical sense of authority in terms of the ability of people to weigh in on like what is true. The trial itself, I hesitate to use the word trial because it's really an oral hearing. During the oral hearing, each side is given an equal amount of time to just speak about their case. But it's not a contentious exchange in which witnesses are queried. There is no presentation of evidence before judges. There is no cross-examination. So the oral hearing is much more of a sort of states coming together to make speeches, rather than the types of exchanges that we might expect from domestic trials. The second major point I would say is that the ICJ tends to perceive the UN itself and its various subbodies as neutral, impartial actors, and they rely extensively on UN reports as a basis for reliable evidence when it's hearing a case. So, for example, in past disputes involving conflicts, the ICJ would refer extensively on written reports that are filed by peacekeepers, the types of things that independent groups send to the UN Security Council. Those are the types of things, like reports written by special rapporteurs for various human rights groups that are sub-bodies of the UN. Those are generally given a very high level of deference, because the ICJ's belief is that because the UN has wide representation, literally every state in the world is a member of the United Nations, that if the institution is representative, that therefore its statements and proclamations must be neutral or unbiased. Um, so there is, in all cases, a general deference that is given to UN reporting when facts might be in dispute. Um, the third point I would make is that most of the time the system works pretty well, because if you are thinking, for example, about a dispute between Uganda and the Democratic Republic of the Congo, I think it's pretty fair to assume that UN peacekeepers who are stationed in a particular province of the Congo are probably going to be impartial in that dispute, because the peacekeepers that are sent in aren't directly tied to the Congo or Uganda. Um, Similarly, if it's a border dispute between two Latin American nations, it's very unlikely that the UN Secretary General or one of his representatives is going to issue statements that are impartial in a boundary dispute. Um, so most of the time, the system of thinking about evidence works pretty well. And I think most people would agree that most UN reporting on most topics is relatively impartial and unbiased. I would say, however, that Israel becomes somewhat special or unique with regard to this issue, because Israel faces challenges at the UN that really no other state does. It's certainly true that states like the United States are oftentimes a target for condemnation in the General Assembly and via special rapporteurs. But I would say, like, the US has its own way of exerting power within the UN through its position on the Security Council. Israel is also a target for various historical, intellectual, religious reasons, but it does not have the same degree of power within the UN to protect itself from abuse that powerful states have. So my fourth point would be, like, in terms of how do we think about this problem and ways to make it better, is Israel really needs international allies and partners to assist itself with this ICJ litigation. And that can come about through stronger diplomatic ties, in which Israel might try to get allies like the United States or the UK, or perhaps some of the Gulf nations, to be a little bit more involved in terms of writing amicus briefs or making positive statements at the ICJ to support Israel. But it also comes about through what people like you and I do, which is, advocating for Israel in our everyday lives, contributing to civil society organizations like Think International, keeping this in public discourse. If you have the ability to talk to a reporter or a policymaker, being sure to share your opinions on these issues with them. All of these things are really important because Israel needs help. And I think, as Greg is going to talk a little bit more about, there are a lot of problems with the evidence that is being put forth in these ICJ proceedings, that is inherently biased against Israel, that provides an incomplete picture of what's going on the ground in places like Gaza. And so, we all have the opportunity to make a positive change on this. And I think I'll now throw it back to Andrew.
Thank you.
Or Greg, whoever wants to go
Thank
next.
you, Leslie. Yeah. Okay. Greg, welcome. Good to
Thank
see
you.
you.
Thank you, Andrew.
All the way from Israel. Looks like you're having a little bit of sun there. Is that right?
No.
But
It's,
you're certainly
yes,
there at an interesting time.
yes. I
Yeah.
came as part of a legal delegation which toured north and south of the country last week, going to the Nova site and kibbutz near Oz, as well as up to the Lebanese border. And we had briefings from the Ministry of Foreign Affairs and the Ministry of Justice and the IDF military advocate general. So that was very interesting. And there was a lot of discussion about the overlap between anti-Semitism and anti-Zionism. And I will finish my little talk today on that topic. But the humorous intervention I made at the start when we realized we were online, that a welcome or acknowledgement of country should be given in Indigenous language, is a custom that has developed in Australia, where we acknowledge the First Peoples of Australia, the Aboriginal and Torres Strait Islander peoples whose civilization in Australia has a 60,000 year history. And so there's an acknowledgement of the Wurundjeri or the Darawal or the Ngunnawal peoples. And I think that's something that's missing in the dialogue and the narrative concerning Israel, is the indigeneity of the Jewish people in this place. So the humor I introduced relates to perhaps the most serious point that this talk will focus on and conclude with. So I'm going to address the evidence that was led by Israel in the oral presentations for the advisory opinion. As Leslie has pointed out, the ICJ isn't set up for the leading of evidence, cross-examination, and for a trial level of evidence and proof beyond reasonable doubt, and even on the balance of probabilities. When it's an advisory opinion, the level of evidence is arguably even a lower threshold for decision making than in a contentious proceeding. A contentious proceeding is one where you have a dispute between two countries, two parties or more, and they each provide evidence in their case. And so in doing that, they provide material that the court has to consider. They provide speeches, and there may only be two parties, so there are going to be maps and historical accounts and documents provided by each of the parties that the court takes into consideration. In the advisory proceedings, where you have 20 or 40 or 60 countries venting their opinions, and they give their opinions as to the law, they may not have any evidence at all to support their arguments. They simply are making an argument that may well be politically based, arguably legal, but generally lacking in historical content, in maps, in actual hard data. So Israel's evidence was submitted in written form to the court on the 28th of February this year. And in part two, Israel's dossier provided what it called the indispensable background to the request that was made to the International Court of Justice. And that indispensable background was in four parts. First, that UNRWA had repeatedly breached its obligations, the UN Relief and Works Agency for Palestinians in the Near East. B, that UNRWA was infiltrated by terrorists and that this infiltration was undeniable. And that really was an elaboration of the evidence post October the 7th. Various caches computer drives and intelligence were gathered by the Israel Defense Forces within Gaza that they didn't have access to prior to the military operation on the ground in Gaza. And thirdly, that despite the evidence that Israel provided to the UN and to UNRWA, they had refused to rectify the situation whereby UNRWA in particular had breached the principle of neutrality for a UN agency. And then consequently, Israel had no choice but to cease cooperation with UNRWA, which was infiltrated by terrorist organizations. So then the Israeli dossier gives examples. For example, in relation to the first proposition that UNRWA repeatedly breached its obligations, it noted that the complaints had been made by Israel, by the USA, and by the EU in relation to UNRWA conduct, that there was clear evidence of hate speech and violence taught in Palestinian textbooks. And, for example, that Suhail al-Hindi, a terrorist senior member of Hamas, was chair of the UNRWA Teachers Federation and was also the chair of the UNRWA Staff Union. Then we have the post-7 October evidence that UNRWA's infiltration by terrorism was undeniable, such as that the IT server farm, which provided the Hamas Central Intelligence Command, was 18 meters under UNRWA's headquarters in Gaza and connected directly to the UNRWA electricity supply at UNRWA headquarters. That once they had member lists and operative lists for Hamas, it appeared that of the 12,500 employees who were Palestinian on the ground in Gaza, of UNRWA, 1,462, that's 12%, were members of Hamas or other terrorist organizations. So that's a serious degree of infiltration. Further evidence that UNRWA employees were engaged in the October 7 massacre and in the holding of hostages after it, that 80 school principals and deputy principals at 60 schools held Hamas operative positions, and that UNRWA, just on a trivial example, used for fundraising campaigns the image of a bereft Syrian girl, a victim of the civil war in Syria, as a Gazan. The plans of Hamas brigades that were uncovered showed operations in schools, and unlike other humanitarian organizations, UNRWA did not even once instance where Hamas had infiltrated into UNRWA or its facilities or used its infrastructure. So it was a failure to cooperate or disclose. The third part of that indispensable background was that despite the evidence that Israel had provided, the UN and UNRWA refused to rectify the situation. UNRWA and the UN Secretary General expressed sympathies for UN employees killed in the current conflict, including terrorists that were killed. UNRWA refused to share the names of 2/3 of its ground staff who it claims were killed, but of the 1/3 of names who were given, a full quarter of them were identified by Israel as being members of Hamas or Palestinian Islamic Jihad. Ultimately, the UN Secretary General instituted an internal inquiry through the UN's own Office of Internal Oversight Services, which is very much a toothless tiger. It scrutinized 19 UNRWA staff members alleged to have participated in the 7th October massacre. It found sufficient persuasive material provided by Israel to dismiss 9 of them. Israel had provided 100 names in full, but these were not further investigated. The terms of the inquiry didn't allow it to inquire about their previous conduct or histories. And another review by something called the Independent Review Group under the auspices of the Attorney General, chaired by Catherine Colonna, who was the Foreign Minister of France previously, also conducted an investigation, although again, its terms of reference were limited to prevent it from investigating allegations that the principle of neutrality was breached by UNRWA. Nevertheless, it found 8 critical areas of UNRWA deficiency requiring immediate attention. So ultimately, Israel concluded it had no choice but to cease cooperation with UNRWA. The Office for the Coordination of Humanitarian Affairs declined to count non-UN trucks delivering aid in its assessments of aid delivery from May to September last year, 2024. UNICEF refused to take into account information published by the coordinator of government activities in the territories of the Israel Defense Forces. For example, on the 10th of March this year, claiming that there was a severe water shortage for hundreds of thousands, when in fact it was ignoring the information provided that Israel had 2 pipelines that it was providing for Gaza. Tom Fletcher, the UN Undersecretary General for Humanitarian Affairs, on the 20th of May this year, 2025, said there were 14,000 babies about to die in the next 48 hours due to starvation. It was completely incorrect, never happened, fantasy. Gazans with pre-existing health problems, genetic deformities were falsely advertised as starving as a result of an Israeli campaign of starvation, and the UN Integrated Food Security Phase classification, which predicts famines, several times, at least 3 times, predicted imminent starvation, which never occurred, and it adjusted its to find false findings uniquely for Israel. The consequence was that on the 18th of March 2024, Israel denied the UNRWA Commissioner General entry into Gaza. On the 2nd of October 2024, the Israeli Ministry of Foreign Affairs declared the UN Secretary General persona non grata in Israel, which means that he's not wanted and his office is not recognized in him as a person. And then on the 28th of October, just under 4 weeks later, the Israeli Knesset, the parliament, adopted 2 laws prohibiting further cooperation with UNRWA. Now, the court disregarded the evidence that was provided in the memorial, the document or dossier that Israel submitted to it. In paragraph 37, the majority of the court, in its judgment, said that the court notes that the case file contains ample documentation concerning the relevant facts. The Secretariat of the UN has prepared a voluminous dossier. In the present case, the court decides that the information available enables it to decide legal questions in a manner consistent with its judicial function. And we can question whether that judicial function is primarily a political function, in this case of advisory opinions. At paragraph 40 in the judgment, the court said it cannot accept the argument that the political nature of the case should preclude the court from exercising its jurisdiction. So it was willing to decide a political case based upon the evidence that the UN had provided. It could justify this by terms of the mandate given to it under UN General Assembly Resolution 79232, adopted at the end of 2024, because that resolution is patently biased and one-sided, based on false assumptions, and it requires inquiry only into the obligations of Israel without referring in any way to Israel's rights or powers or self-defense and security concerns. And that resolution deliberately hides from view the conduct of the UN, and in particular, UNRWA's breaches of the fundamental UN principles of neutrality, impartiality, and independence from political influence. So what we have is a complete absence of UN agency investigation of the most extensive infiltration ever of a UN body by a terrorist organization. In effect, the UN is at war with Israel because the UN membership is dominated by the 57 members of the Organization for Islamic Cooperation and its various allies in South Asia and Latin America, whether by reason of anti-imperialist, radical leftist inclinations or oil dependency or simply neighbor proximity, as in the African Union. So we have the UN effectively at war with Israel, delegitimizing Israel, and the majority on the International Court of Justice bench, therefore serving UN purposes by ignoring the inadequacy and poor quality of the UN Secretariat provided evidence before it. As Judge Julia Sebutinde noted in her dissent, the ICJ, the Court of Justice, lacked a sufficiently reliable evidentiary basis to accurately assess the current degree of effective control exercised by Israel over the Gaza Strip when it was assuming Israeli control and obligations as the occupying power. So, in effect, it's a circular system of evidence and reasoning, a solipsism where the court talks to itself. The majority judgment of the court completely disregards the evidence provided by Israel, which is the central party targeted here and the focus of the advisory opinion, and instead it relies upon the evidence of only one party, the other party, the UN. And it's not coincidental that those UN institutions that provided the evidence and the mandate for the court and the terms of reference of the request for an advisory opinion are the political, financial, and institutional masters of the judges of the International Court of Justice. So the judges become political instruments, making judgments within the confines of political necessity for their own continued agency, survival, and reputations. For the UN, it's got to be remembered that Hamas is legitimate. It hasn't been listed as a terrorist organization due to the majority voting pattern adopted in the General Assembly, and which is reflected through the actual nationalities geographically represented in the Secretariat of the UN. Hamas is legitimate, and Zionism is racism. And so, as Judge Sebutinde noted in her dissent, the majority judgment disregards the complex realities of urban warfare, including the use by Hamas of Palestinian civilians and Israelis as hostages or human shields, and its militarization of civilian infrastructure. So I'll conclude by saying that I want to answer the central question, which is the title, at the heart of the title of this webinar, which is the International Court of Justice instrumentalizing lawfare against Israel and promoting anti-Semitism? And the bottom line is the answer is yes, because for the UN, and as is clear from the complexion of the judgment of the court, Zionism is a bad thing, despite the fact that Jews are indigenous to the land of Israel. Their language, history, legends, landmarks, and sacred sites are all there. Their religion, prophets, direction of prayer, prayers for the next year in Jerusalem, and the continuity between the ancient and modern culture all indicate indigeneity. So to deny the children of Israel, the religion of Israel, and the land of Israel is Semitic. The majority judgment goes further. It also undermines fundamental principles of the international rule of law by reasons of its bias. And that's another issue. Thanks very much, Andrew. I'm a bit over time.
Thank you so much, Greg. That's been very helpful. Leslie, you're back on. How do you respond to this? Do you agree with Greg? And particularly on this question, I think of the burden of proof. Because it seems to me that what Israel did is it said, we are going to terminate our relations with UNRWA because we don't trust UNRWA. It's been infiltrated. We're a sovereign state. We have a right to work or not to work with a UN agency. And the court is basically saying, well, Israel, you haven't provided sufficient evidence to back up your claim. We're forcing you to work with a UN agency. That seems to me to be a very strange approach to the burden of proof.
Yeah, well, I think that the ICJ has a very bad approach in terms of dealing with this evidence issue. Now, they never explicitly outline what they would consider to be compelling evidence. But I think sort of the standard that we can infer based upon seeing now a lot of rulings like this in different contexts is that there basically is no information that Israel could provide that the court would find compelling, because because the only information source that the ICJ is essentially willing to trust when a country has been accused of something is the UN, right, or one of its sub-bodies. Um, and so in that sense, it's very troubling to think about someone who has been, or, a party that has been accused of violating international law, essentially has no way of defending itself beyond, trying to convince the UN to generate evidence that supports the country's own account. Because that's essentially the only evidence that the ICJ is really willing to consider. Now, obviously, if Israel were to present evidence that was harmful to Israel's interest, they would probably accept that. But I would say, like, I don't think that this is necessarily a problem that's unique to Israel in terms of the way the court operates. Like, this is something that we see in other cases as well. Like I mentioned, the Congo versus Uganda case from a few years ago. The court didn't give any deference to information submitted by Congo or Uganda either, right? The only information that it would consider as being sort of pristine and reliable is information that came from the UN itself. So that suggests that really the battle in terms of providing good evidence is trying to get the UN to issue reports and findings that are themselves, decent, credible, informative, etc.
Okay, so that takes us to the UN itself then, really. It's not so much, you're saying it's not the court itself that's the problem. The court's applying an approach but we have a bias within the UN system. I think that's,
Absolutely.
Greg, what you're saying as well. Almost inherently within the UN, there is an anti-Israel bias. Is that correct? And if so, why is that the case?
Yeah, I mean, I definitely think that's the source of the problem. And I would say, I'm obviously trained as a political scientist, so I tend to think that these problems come from the way the institutions are structured. Um, we know that the institution, all of the various UN sub-bodies are explicitly required to operate based upon the idea of geographic representation. So there are limits to how many employees in every single UN bureau can come from a particular country. There's tremendous pressure to have more staff members coming from the developing world or the third world, if you prefer, whatever term you prefer. Um, and so, you have the people who are put in these positions of power within the UN bureaucracy just by virtue of their upbringing, their education, their training, tend to be biased against Israel. And those states that have historically been allies of Israel, like the United States, the UK, etc., have very little ability to actually influence the way the UN bureaucracy works.
Greg, what's your thoughts on this?
Well, I agree with everything that Professor Johns has said. There are big countries and there are little countries, and there are a lot more little countries than there are big countries. And India, with 1.33 billion people, has the same vote as Nauru with 5,000 people. They're considered sovereign equals. It's a nonsense in reality, and as Leslie has put it, it's due to structural misalignment within the UN system, which is ultimately going to be a cause, perhaps not the sole cause, of its downfall. And ultimately, the United Nations will go the way of the League of Nations. It'll collapse under the external pressures and its own internal dissonances. And that will be a very difficult time I expect, for our children. And so it's easy for a lot of small countries like Comoros and the Maldives to gather votes against the Jewish state, and we see that also within the Secretariat in the New York Delegates Lounge. People tend to gather in their political or geographically regional blocks because they have more culturally in common. As you can tell from my accent, I'm from Australia. Australia is located proximate to Southeast Asia, and yet we're not considered part of the Asian bloc. We're considered part of Western Europe and others, as it's called. And even though that's the other side of the world from where we are geographically located. So cultural contiguity factors far more heavily than geographic location. And cultural contiguity has a lot to do with religion, because religion sets a lot of the parameters for cultures. And so you find that in Christian Europe and in the Muslim Middle East, they're a Ramadan feast or a Christmas fair are both religious and cultural things. And Israel is isolated as the only Jewish country in the world. And it's not India. I think that there are only two Hindu countries in the world. India, and I'm just having a mental block, just north of India, the Kathmandu, and you'll help me out, but my apologies. But because of the size of the population, India will sort its business successfully. I was told a story last week of the Israeli legal advisor approaching the Chinese legal advisor at the International Law Commission and identifying a precedent that would be, it was directed against Israel, but would be bad for China. And the Chinese delegate's response was, there is no precedent for China. China is a permanent member of the Security Council. It's the largest economy in the world. This is just the realpolitik. And Israel has a geographic footprint that is, a little bit more than twice the size of Sydney in Australia, and a population that is relatively small. So it's an easier victim, and it's isolated, and therefore it is a victim because of the religious and cultural tensions that focus upon it. And the UN serves that purpose, both in its voting patterns within councils and committees, and within the attitude of the members of its secretariat.
I'd like to thank you very much. I'd like to turn to look at the court itself then, and the judges. The court is made up of 15 judges. They represent different legal traditions around the world, different parts of the world. But those judges are supposed to be the protectors of international law and justice. They are the gatekeepers, really, to make sure that this system works and it functions well. Are they not fulfilling their task? And if you look at Judge Sabatindi, who was the only one in this latest advisory opinion to issue a separate opinion, why does she take the approach she does and the others don't? What is the difference? And what is motivating this majority to not want to intervene to see this imbalance, to see this bias that's inherent in the system? Leslie, what's your thinking?
Yeah. Well, as you say, the judges are chosen to reflect geographic representation. There are different seats that are set aside for different regions, and judges are elected within their regional groups. And there's a very strong norm of sort of turn taking within each region. That being said, they are explicitly meant to represent sort of the judicial views of the countries and of the regions that they're representing. In practice, I would say that oftentimes these judges really are part of sort of an international cosmopolitan elite. They tend to all have had some sort of legal training in the US or in Europe, regardless of where their home country is. Most of them nowadays have worked at elite universities in the US and Europe at some point. So they are, in some ways, more homogenous than you might imagine. Because they are part of the same sort of intellectual circles. They go to the same conferences together, work at the same types of places. Um, that being said, like we all are raised with inherent sort of biases in terms of how we were educated as children, the viewpoints that lead us to study different subjects and things like that. And so, while I think I don't know if they would acknowledge that there is inherent bias in terms of how the UN system works with regard to Israel. I don't know that they would acknowledge that. But I think that they would say we are serving justice by getting involved in these issues having to do with the treatment of civilians in Gaza. Um, Now, what is somewhat strange, though, about the ICJ is like unexpected things can happen, truly quirky things. Like in previous rulings, Judge Sebutinda from Uganda, I would say, is much more pro-Israel than the Israeli judge has been, that was appointed to hear the contentious case in the Gaza case brought by South Africa, excuse me. So, truly unexpected things can happen at the ICJ just because you have a very small set of people. Judge Sebutinda, for example, my understanding from, just sort of scuttlebutt and gossip is that part of the reason why she got her seat is because she was so annoying to President Museveni in her home country because she was constantly trying to prosecute Museveni and his various generals, that one way that he tried to get rid of her was by saying, give her a seat in The Hague, right? Get rid of this noxious person who's always trying to come after me and prosecute me. So sometimes these people end up going onto this bench for unexpected reasons. And, we're now in a situation where the judge from Uganda is arguably, Israel's greatest ally. So truly unexpected things can happen in this court because of those idiosyncrasies.
How do you read her separate opinion? Do you think it's a credible approach? Is she taking the approach that you would think the court as a majority should have taken?
I am very respectful of her views in this set of cases involving Israel. I mean, this is just my own personal opinion. I think that that both the contentious case as well as the advisory opinions are just mired with really incredibly deep, troublesome political questions. Um, and I'm not really sure whether it is appropriate for the ICJ to be ruling in on all of these issues. Now, that being said, it's much harder for the ICJ to get out of giving an advisory opinion because they don't have sort of the same level of sort of jurisdictional procedural grounds on which they can try to avoid ruling on the merits. Um, but I think she staked out a very principled line of argument that should certainly be carefully considered. And I'm kind of surprised that more countries haven't been willing to ally with her, or more
Mm,
judges, rather, excuse me.
right. Were there other judges who, because a number of them have, every judge can write also a dissenting opinion or a declaration, something additional to what the court does. And so they do this. Did a number of them kind of indicate sympathy for Sabatindi's view or criticism of the majority's view, or was it pretty much, were they all in agreement with each other?
So I haven't read the dissents on this UNRWA opinion, right? But with regard to sort of earlier rulings on the contentious case by South Africa, it does seem as though Sebutinda is sort of standing on her own. But maybe Greg is more familiar with the latest set of pleadings.
Yep. I would make a series of comments. One is that Julia Sebutinda is exceptional in the sense that she comes from a position previously as a judge.
Okay.
And that's unusual on the ICJ. Judge Bandari from India is also a judge. So we have two judges who were previously judges, and that's not usual.
So what were the other ones if they were not judges?
So the others are all diplomats. Well, usually they're mostly diplomats. In this case, we look at, just what Salam in that judgment was Lebanon, Foreign Ministry, Slovakia, France, Somalia, China, Mexico, South Africa, all from the foreign ministries. So basically, they're diplomats. Their job is to serve the national narrative, the national priorities. Yes, the UN Charter, or rather the statute for the International Court of Justice at the back of the UN Charter, requires that they exercise their judgment impartially, with integrity and so on, but they're fundamentally answerable to their ministries, the people that have shaped their careers. There's an unusually high number of academics currently on the bench, from Japan, Germany, Australia, Brazil, USA, and Romania. So that's about half. Normally it's less coming from academia. But as Leslie's pointed out, they're culturally homogenous. They get their agency, their meaning, their why in life from prosecuting the case for international rule of law as they see it, which is basically to promote the United Nations organ, even though it is so faulty. The philosophy is, well, we muddle through, we've got what we've got, and we have to make the best of it, and we want the institution to survive and to prosper. So there's a cultural homogeneity in that sense, but you've got to bear in mind that it's usual that the majority of the bench are diplomats from the foreign ministry, usually the chief legal advisor or something of that nature. And so Julia Sebutinde is unusual for being a judge, unusual for her stand on principle, and unusual for her willingness to attract the opprobrium of her peers and even her own country. So you could think of it
Greg,
a little bit
why is it important that she's a judge? What difference does that make, do you think?
Well, it just puts her in a minority in terms of her legal cultural experience, rather than shaping advice in order to serve a government objective in an international conference or committee. Her history has been to deliver justice based upon the evidence provided by the parties before her in an impartial way.
So I think she's probably more inclined to be more aware of rules of procedure, rules of evidence, than judges who come from an academic background. But that's
True.
right. Yeah.
True. And also on the other point concerning separate opinions and dissents from other members of the bench, they tended to be more anti-Israel than the majority judgment. So the majority judgment involved some consensus then that was, it entailed consensus that involved some compromises. Not all the judges were happy with those compromises. So when they came to give their separate additional opinions, like Judge Robledo from Mexico, he was positively vitriolic against Israel. So I think that opinions that were in the consensus were moderated by judges like Germany's Judge Nolte and probably USA's Judge Cleveland, and particularly maybe Romania's Judge Orescu. So they would have created a central gravitational pull, and then other judges in their separate dissents or separate opinions could make a bolder individual declaration against the Jewish state.
Okay, thank you. Look, we've got one other question I want to deal with, and then we're going to wrap up. The question is if you could please just comment on the far-reaching negative implications arising from the ICJ's bias, based on the UN bias, that fanatics, laymen, armchair critics pick up on when they're criticizing Israel. So I guess the point here, the suggestion is that, what the court says is not does not remain in The Hague. It's not remaining in the hallways of these institutions. It's being used on the streets. It's being picked up in the way that people talk about Israel. Do you have any comments on that?
It is a bit troubling, and I do find it very strange. I've been studying the ICJ and writing about it for over 20 years. But most of the people that I work with at UCLA had never heard of the ICJ, didn't know what it was, thought I was very strange for focusing on this strange institution in The Hague until, South Africa filed its case against Israel. Then suddenly everyone was very interested in what the ICJ had to say. Um, so, um, so it is very, very odd to me, from as someone who's like studied this institution for a very long time, that this institution that no one cared about, 3 years ago, is suddenly now the type of thing that the person on the street knows about. Although oftentimes they don't say the name correctly. They talk about the International Criminal Court interchangeably with the ICJ, right? Um, so I do find it very strange, and I don't quite have an explanation for that. Um, but if it's any comfort, or it's probably not any comfort, but there have been a lot of organizations that sound quasi-official, that are led by nonprofit groups and civil society groups, that have been going around saying very bad things about Israel for multiple years now. And I'm not sure that the average person on the street really knows the difference between these different things. So, when Amnesty International puts out a report saying genocide, um, people read about that in the newspaper, and I'm not sure that there's really a fine-grained understanding between how the ICJ is different from Amnesty International, is different from Human Rights Watch. So I don't necessarily, I think whatever the ICJ does is another piece of sort of unhelpful information that's going out into the internet world that people are picking up. But I don't know that it's a particularly damning piece of information, because I honestly don't think that most people even still understand what this institution is.
Thanks very much. Greg, what's your thought? I mean,
Well,
if I
as
could
an
just interject
international,
there, just say it. One can't help but have the impression that the attack of the 7th of October, which was a brutal attack on the existence of the Jewish people as such, is somehow connected with these attacks in the court. I sat in the court for a week in 2024 in the first advisory opinion, well, not the first, the second, but the first one since 7th of October. And the atmosphere of vitriolic hatred towards Israel was so palpable in the court. And it just occurred to me that, that sentiment is I felt like, being attacked in a way that Israel itself was being attacked. And one can't help but think that these proceedings, and therefore what the court itself ultimately says, is part of a campaign to demonize, to ultimately delegitimize the state of Israel. And the court's kind of playing into that. Is it going too far?
no, I wouldn't disagree. And my Old Testament knowledge could be better. But if I remember correctly, when um, Balak, the king, called upon a seer, Balaam, to curse the tents of Jacob, uh, the seer was about to utter the curse from the top of a hill overlooking the tents, And instead, he ended up saying, "Blessed are the tents of Jacob." But he also said, "This is a nation that shall dwell alone." And Israel dwells alone today within the UN. I agree with everything that Leslie said. Maybe one of the ways of thinking about the ICJ, the International Court of Justice, which has the same acronym as the International Commission of Jurists and can be easily confused, is that the name is inflated. It's not the World Court. It's not the International Court of Justice. It's the UN Court. It's an appendage of the UN. And we need to keep that in mind when considering what emanates from it.
Thank you very much. Well, and thank you both of you so much for spending the time, for sharing your deep and extensive knowledge and understanding of these institutions. I think we're grappling with a very, very serious issue and problem we're going to keep grappling with. It's not going away. There'll be more cases. The genocide cases, there are 2 of them before the court, are continuing and ongoing. This will keep coming back at us. Quite possible we'll see more advisory opinions relating to Israel.
There's still a whole month to go.
What's that?
They usually request one in the last 3 weeks of the year. We've still got a month to go.
That's right. They love to do it just before Christmas or around that time, don't they? Okay. Well, thanks a lot. And for all those who've been viewing and participating in the webinar, thank you so much. Do encourage you to support our work, to keep in touch. You can, if you haven't already, become a subscriber to the work of Think on our website, www.think.info. And on the homepage, you'll find a place where you can sign up for our newsletters, keep informed about future events. And please do follow us and support us. We need your support. And share the word so that next time when we meet on this webinar, we'll have even more people from around the world. Thank you to Professor Leslie Johns and Professor Gregory Rose. And thank you all for watching. God bless. We'll see you next time. Thank you.